Our guest today in this segment via Skype is Quentin Brogdon. My name is Gordon Griffin. Quentin knows a little something about what we're going through right now about coronavirus and how it might very well affect your business. He practices plaintiff's personal injury trial law, a fellow in the Invitation-Only International Academy of Trial Lawyers, and a fellow in the Invitation-Only American College of Trial Lawyers. Let's talk to Quentin live now via Skype. Hi, Quentin. How are you, sir?
Hello, Gordon. How are you doing?
Very, very good. I know that we are kind of entering into uncharted waters. In fact, we've now had we've had our belly full of just a few months now of coronavirus and how it affects everything we do, just everyday life. It affects even sports, what we eat, lifestyle, so on and so forth. But it also affects the workplace. It affects how we conduct our business. I know that right now I'm talking to you at home, right down the hallway from my bedroom and in the man cave with a studio that I have here. And so I'm very blessed and fortunate to work from home. But I know that there are a lot of workplaces that are doing the same thing. I mean, you've got people that are working from home. And obviously that does present some challenges in this day and age, doesn't it?
It sure does. Lawyers and non-lawyers alike, Gordon, are living through what might be called law in the time of corona. At the end of Gabriel Garcia Marquez's book, Love in the Time of Cholera, there are two lovers on a ship that it's about to dock on the final port on the river, and the lovers don't want to be seen in public. They don't want to be embarrassed, so they ask the captain to raise the yellow flag of cholera so that the ship won't be allowed to dock. And then the lovers on their ship are basically exiled to cruise the river, perhaps forever. I think today, lawyers and non-lawyers alike maybe feel exiled, perhaps forever, from the legal world and the business world and the employment world we knew before COVID-19 made its ugly appearance on the planet at the end of 2019.
You know, this is one of the big questions that really comes up quite often in working from home or really working right now, and that is the area of travel. You know, we talk about, well, frankly, I haven't had the big summer vacation this year, and I know many haven't, but travel comes up, and places like Twitter, for example, asks its employees to work remotely. LinkedIn, Square, Lyft, all these companies, Microsoft, JP Morgan Chase, we could go on, and they've imposed sharp restrictions on travel. Now, is this something that employers can do and will do?
Well, employers are guided and are supposed to be following OSHA's general duty clause, so-called general duty clause, and it says that employers have to provide a workplace free from recognized hazards likely to cause death or serious physical harm. Many have argued that OSHA has been kind of asleep at the wheel during COVID. OSHA says follow the CDC guidelines if you're an employer. That's 6-foot distancing, temperatures of your employees, disinfecting surfaces, masks, physical barriers, all those things we see, you know, in grocery stores and elsewhere now. But beyond that, OSHA has not provided a whole bunch of guidance. They did issue a 35-page booklet that, you know, recommends frequent hand washing, respiratory etiquette, providing tissues, and considering masks, not necessarily requiring them, depending on whether COVID-19's, you know, in the vicinity. But the OSHA 35-page booklet says it's not a standard or a regulation, and it doesn't create any legal obligations. And OSHA has been very lax, many would argue, in stepping into workplaces and making sure that employers are taking care of their employees. So employers largely have been left to their own standards, if you will, and their own judgment about what's reasonable, including, you know, travel restrictions, how to set up the workplaces, whether to allow people to work from home and under what circumstances. Employers largely have been left to their own devices to sort through that and determine what's reasonable under the circumstances.
Via Skype, we're visiting with Quentin Brogdon here on the community for the next few moments. You know, I started thinking about this too, Quentin, and that is those workers. My daughter, for example, at one point here was doing this. That's the DoorDash, the delivery services, Amazon Prime. what leg do they have to stand on? The delivery driver who says, "Well, I'm being exposed every day. I mean, I have no idea what I may be dealing with, what I may be facing." Conversely, let's take the packaging for example. You order. I just ordered something a couple of weeks ago on Amazon. So, what kind of recourse does the average person have when it comes to being in contact with others performing those kinds of services?
The traditional recourse that workers had against their employer was and is workers' compensation. Texas is one of the few states that allows employers to opt out, to decide not to provide workers' compensation insurance, and a sizable percentage of employers have opted out of it in Texas. When they opt out, when an employer opts out, then they can be sued down at the courthouse, and a jury can decide whether or not they exercised reasonable care under the circumstances. There have been discussions and there have been bills floated, including one in the United States Senate, to essentially immunize employers and businesses from all COVID-19 claims. I and many others believe those bills are bad because they would deprive your daughter and other workers of the ability to hold their employers accountable. We trust jurors, and we've trusted them for hundreds of years to decide what's reasonable. We trust them to award or not award billions of dollars when one corporation sues another. We trust jurors to decide whether a criminal gets the death penalty. But some are now arguing jurors can't be trusted during COVID-19 and that we need to pass, dramatic draconian laws that keep employers and others from being held accountable. So the remedy for your daughter or anybody else is the courthouse, or filing, if their subscriber, their employer, is a workers' compensation claim.
We have just a few more minutes left here, Quentin, but I had a stroke back in April, and so
sorry to hear that.
Yeah, I know and I'm kind of working my way back, and one foot in front of the other. But I think about it's a horrible time. Really, it's just horrible to have a stroke naturally, but during the time of COVID-19, where you have all kinds of, when I was in the hospital, my family couldn't come visit, and rehab, same idea. So we had to be very creative with FaceTime and other kinds of ways. But let's talk about employees just in general. I mean, just being sick, a simple cough, a sneeze, maybe it is, God forbid, a stroke or a heart attack. And those kinds of things that you start walking down the COVID-19 trail and thinking, well, my gosh, could that be the result of COVID? And if so, what kind of, obviously we would say, well, they can't come to work. They shouldn't be at work. But what kinds of what legal recourse does the average employer have right now when it comes to infected or at-risk employees to stay home?
Well, employers need to be taking, again, reasonable steps, following the CDC guidelines. There's a balance. You're correct. Employers traditionally were not able and not allowed to, pry into the health concerns, the individual health concerns of their employees. However, it is now generally understood that COVID-19 presents such a menace, and the results of allowing employees who are sickened with COVID-19 into the workplace are bad enough that we need to tilt that balance somewhat, and we can allow, for instance, employers to take temperatures of employees, and if someone is sneezing or coughing, they can be asked certainly to go home. I think employers should be enabling their employees to speak up, enabling them to work from home, not penalizing them if they're sick. Don't incentivize sick employees to come in. If they're sick, pay them when they're off and enable them and incentivize them to speak up and say, you know what, I don't know what I have, but I have a cough today, and maybe it's not the best idea if I come in. And so I think it comes back to reasonableness, reading the CDC guidelines, and just trying to strike a balance.
Yes, sir. And again, as I'm just reminded once again, that employee handbook is ever changing, is it? I mean, when you think of rules and regulations and how we handle these kinds of things, if it's not COVID-19, it's the next, God forbid, the next illness or sickness or pandemic that happens in our land. And again, Quentin, I thank you so much for being here from wherever you might be, and I'm at home here, and thank you for being here on such short notice.
Thanks for having me on, Gordon. Stay safe, and of course, we'll all be watching developments, and hopefully we'll have a vaccine soon for this dastardly virus.
You bet. Thank you so much, sir. Take care. Thank you. Quentin Brogdon, who joins us here via Skype today in this segment of the community as we talk the coronavirus and the employer and the, again, that employer handbook. Man, the employee handbook changes. Legal guidelines for navigating the upheaval. Quentin Brogdon, our guest here in this segment of the community today.